Hello everyone, welcome to BYJU'S exam prep. I'm Nivedita Raje and today we are going to start our amazing and mind-boggling series Last Lap to CLAT 2023. Right, so this is one in a million series, trust me. मतलब तुम्हें free में इतना content कहीं पे भी नहीं मिल सकता. What is the agenda of the series? We understand that during the last preparation or the last time of preparation, students get panicked. Revision ke time pe, preparation ke time pe. Also, the students who are just beginning to prepare for CLAT 23 get confused about the fact about what to prepare. क्या पढ़ना है, कहाँ से पढ़ना है, मैम, where to begin from. और जो रिवीजन करने वाले बच्चे हैं वो भी नहीं समझ पाते कि कैसे रिवीजन कर. Prepare only what is most necessary so that you can save time and utilize it for practice. अब इस सीरीज में आपको सिर्फ उतना ही पढ़ाया जाएगा जो आपके एग्जाम पॉइंट ऑफ व्यू से बहुत बहुत ज्यादा जरूरी है. आप उसको इस सीरीज के थ्रू रिवाइज कर सकते हैं. जो आपको पढ़ाया जाएगा उससे रिलेटेड पैसेजेस होंगे, जो नहीं भी पढ़ाया जाएगा उससे भी रिलेटेड पैसेजेस होंगे. आप पढ़ सकते हैं, साथ साथ में प्रैक्टिस कर सकते हैं, एंड ऑन अ लाइव प्लेटफॉर्म यू कैन डिटरमाइन द लेवल ऑफ योर प्रिपरेशन. और आपको और मेहनत अगर करनी है तो किस एरिया में करनी है. इफ यू आर एबल टू डू वेल इन द पैसेजेस दैट यू आर गोइंग टू कंडक्ट, अगर आप उसमें अच्छा परफॉर्म करते हैं, बिल्कुल लास्ट स्टेजेस पे, नवंबर चल रहा है, दिसंबर में एग्जाम है, तो आप समझ लीजिए कि आपकी प्रिपरेशन बहुत बढ़िया है और आप 18 दिसंबर को बहुत ही बढ़िया परफॉर्म करने वाले हैं. बट इफ यू आर लैकिंग बाय एनी चांस, यू विल गेट टू अंडरस्टैंड वेयर यू आर लैकिंग एग्जैक्टली, एंड यू स्टिल हैव टाइम टू इम्प्रूव अपॉन योर mistakes, right? So this is the importance of this series. हम उन्हीं टॉपिक्स को डिस्कस से बहुत इंपॉर्टेंट हैं जो इस बार एग्जाम में आने के सबसे ज्यादा चांसेस रखते हैं. Right, so we have analyzed the previous year question papers. Some topics will be discussed while others will be told to you or will be discussed in a brief manner and you can revise them later. Right, so it is a exhaustive series. It is an exhaustive series which is going to comprise of everything that you need towards or to your for your last minute preparation. लास्ट मिनट प्रिपरेशन में आपको जिस भी चीज की जरूरत है, जैसी भी जरूरत है, प्रैक्टिस करने की, पढ़ने की, समझने की, कंसेप्चुअल क्लैरिटी की, वो सब है यहाँ पे. उस पर्टिकुलर टॉपिक का आपके एग्जाम में क्या कंट्रीब्यूशन है, क्यों हमें ऐसा लगता है कि वो टॉपिक आ सकता है, ये भी आपको बताया जाएगा. राइट, सो दिस इज once in a lifetime kind of a series, trust me. Right? Okay. Right, so is this also important for AILET? Vipul, for AILET we have begun another last lap. So of course, if you know consider the syllabus of the exams, AILET and CLAT both have similar syllabuses. The pattern might be different, but what you need to study is more or less the same. So you can actually take the classes from the CLAT last lap and the AILET last lap. Together, they would give you everything that you need for your exam, right? So today we are going to do the important questions from the Law of Contracts or Indian Contract Act 1872. We'll do the most basic and the most important topics. You have faced contract in a lot of passages. So contract is the most beloved law of consortium. They choose to frame passages from this law because it fits their pattern. The kind of questions that they want to give to their students come very easily from contract pattern. The critical reasoning pattern that they have introduced after 2020, contract fits the picture like completely, and that is why maximum questions come from contract. But as per the trend and the inclination and what consortium does, actually I feel that contract is going to stick to the basics. They have asked uh, the factors that affect consent, they have focused on them. They've also focused on other aspects of contracts. These are the aspects that I believe might be asked this time in the examination. अब ये कॉन्ट्रैक्ट का बिल्कुल इनिशियल स्टेज है, इसको ऐसा लगता है कि ये तो क्यों ही पूछेंगे, ये तो बहुत ही आसान है. कई बार बिल्कुल आसान टॉपिक से पैसेज आ जाता है और तुम्हें लगता है यार इसको तो मुझे बेहतर रिवाइज करना चाहिए था, मैं टॉपिक डिफिकल्ट कॉम्प्लिकेटेड टॉपिक्स में लगा रहा और इजी टॉपिक्स को मैंने इग्नोर कर दिया और इजी टॉपिक से पैसेज आ गया. राइट तो उसी तरह का एक टॉपिक हम करने वाले हैं. Yep. How many attempts are good in AILET? Considering that AILET has a negative marking, you should only attempt the questions that you are most confident in. You cannot be adventurous in competitive exam which have a negative marking scheme. You will lose a lot of marks. So unless and until you're 95% sure in a particular question, do not attempt it. Leave it. Okay. Baylor Bailey seems important, but they're not. Okay, Vibhu, Baylor Bailey, they seem important, but they're not as important. Like I said. So what are we going to discuss? We're going to discuss the weightage, the introduction, offer, acceptance, competency to contract. These are the topics that we are going to discuss. Yep. So as you can see that law of contracts comprise about 25% of the uh, questions. About 25% of the questions come from contract. Okay. Good evening, guys. I'm sorry I was busy in introducing the series. I completely forgot to welcome you all. Welcome everybody. Good evening. कैसे हैं आप सब लोग? और चलिए आज पढ़ाई शुरू करते हैं और आज से बिल्कुल कमर कस लेते हैं कि सारे के सारे सेशंस अटेंड करेंगे, अपने फैकल्टीज की सारी बात सुनेंगे, बढ़िया करके रिवाइज करेंगे और क्लैट में बिल्कुल झंडे गाड़ देंगे, नाम रोशन करेंगे मेरा भी और अपने पेरेंट्स का भी. नहीं ठीक है? तो ये एजेंडा और ये ऑब्जेक्ट लेकर चलना है और बिल्कुल एंड के डे तक प्रिपरेशन करनी है और बढ़िया प्रिपरेशन करनी. ओके. One passage, you can actually expect one passage from this 100%. एक पैसेज आप इन टॉपिक्स में से 100% एक्सपेक्ट कर सकते हैं. ओके. तो बस एक बढ़िया सा विल पावर फॉर्म कर लो. जस्ट set it in your mind that we are going to work our level best during these last days. इतनी मेहनत करूंगा मैं इन आखिरी दिनों में कि जो देख रहा होगा मेरी मेहनत को जज कर रहा होगा वो भी सोचेगा यार बच्चा बहुत मेहनत कर रहा है, इसको तो पास कर ही देना चाहिए और एनएलयू का स्टूडेंट बनूंगा मैं. तो ये दिमाग में लेकर चलो, ईश्वर पे भरोसा रखो और चलो शुरू करते हैं. लॉ ऑफ कॉन्ट्रैक्ट्स 25% सिलेबस आता है उसमें से, मतलब 25% क्वेश्चंस लॉ ऑफ कॉन्ट्रैक्ट से फॉर्म हो जाते हैं. लाइक आई सेड, इट इज a kind of a law which fits the current scheme of CLAT, and that is why they're more inclined towards this law. Right. So if you clarify contracts, if you understand the passages and what kind of questions come from contract, it is easy to solve other laws also. It might be hard to believe, but it is true. अगर आप contracts को अच्छे से समझ के उसके passages को deconstruct कर लेते हैं और question solve कर लेते हैं, तो बाकी laws को पढ़ना, समझना, solve करना actually easy हो जाता है. क्योंकि application based question सबसे ज्यादा contracts है. समझे? सबसे ज्यादा कॉन्ट्रैक्ट से एप्लीकेशन बेस्ड क्वेश्चंस आते हैं. तो इन्फरेंस, कंक्लूजन, जो भी कुछ कॉम्प्लिकेटेड चीजें तुम्हें करनी पड़ती हैं पैसेज को सॉल्व करते वक्त, कॉन्ट्रैक्ट में अगर सीख जाते हो तो बाकी लॉज में बहुत इजीली कर लोगे. ओके. नाउ लॉ ऑफ क्राइम 17%, law of torts has about 21% weightage, Latin terms only 6.5. In CLAT, I believe there might be just one or two questions, not more than that. And those questions would be pretty easy. You must have studied those maxims. And if you haven't, just leave them. Constitution does not come as much. They remain constricted to certain arenas of constitution. They do not dive deep, and there's a reason. Like I said, constitution doesn't really fit the scheme of CLAT, but last year they were pretty inclined to include as much constitution as possible. In fact, ये जो sample paper 2 release हुआ है इसमें core law में सिर्फ constitution का passage है, ठीक है, और बाकी सब मिसलेनियस, इकोनॉमिक टाइम से ले लिए, प्लीडर से ले लिए, बिजनेस स्टैंडर्ड से पता नहीं कहाँ से ले लिए, सारे बहुत ही नॉन कन्वेंशनल से मिसलेनियस से पैसेजेस हैं. दे आर नॉट रियली लीगल, दे आर नॉट रियली, दे डू नॉट कम फ्रॉम कोर लॉज, बट दे आर, you know, they're not that difficult if you ask me. Miscellaneous about 18.5. Falguni, if you understand contracts and you're still losing marks, you're not as focused, sweetheart. You're not reading passages carefully. you're missing certain points and your concepts are not that clear. Maybe you are a little overconfident. Okay. Yep. Now, moving on. Constitution of India, CLAT 22, this was the weightage. 50% of the legal came from Constitution and rest was divided evenly between all the core laws, right? The okay, so this is the source and this was the topic. Free consent was actually asked from contracts. So free consent is, I believe that free consent might not be there in your exam this time. Okay, because they have actually asked questions from free consents in many exams. So they might consider doing something else or including something else other than free consent. Okay. So 21, these were the topics and this was the percentage. CPC 12.5, there was one passage from CPC, res judicata. Family law, one passage. Law of contracts was pretty much all over the paper. Like there were many passages from law of contracts. Tort law had one passage, Indian Penal Code had one passage, and miscellaneous, basically it was constitution only, compassionate appointment, just one passage. Okay. Aryan, we will actually have a separate session in which we would be discussing the sample paper, the one that is released today. Okay, so what can you gather from the sample paper will be there in that discussion. So section 4, CLAT 21, they focused on section 4, section 10 and 28. Okay, the level was medium, it was not easy, but it wasn't difficult also. These were the topics that are commonly taught, like you should be aware of these topics if you are studying for CLAT or any other law entrance. So they did not really go for a topic which was unconventional, could not be believed that was included, nothing like that. For the normal से general से topic आए थे section 4, 10 और 28 से. Okay, so before we proceed to what we are going to study, you should know that we have an all India mock test, open test for AILET starting from today till 12th of November. You need to attempt it. AILET is as important as CLAT. In fact, there are many national law universities that fall way below the National Law University, Delhi. The seats are less, the competition is very difficult, plus, but it is in Delhi and it has more exposure, like more exposure than any other city. So students who actually are serious about going to NLUT for their graduation should consider taking this. Very important. These kinds of opportunities are hardly there in which you can attempt a test or take a test among thousands of aspirants and then judge your performance based on that. ठीक है, अकेले अकेले तो आप मॉक्स देते ही रहते हैं, प्रैक्टिस भी करते रहते हैं, गलतियां भी समझ आने लगती है, पर हजारों बच्चों के बीच में मॉक देने के बाद जो पता चलता है वो होती है सच्चाई. ठीक है, और उस सच्चाई का सामना करके तुम पता लगा सकते हो कि भाई वाकई तुम कितने पानी में हो. गलतियां हैं तो गलतियों को सुधार लो, और अगर आगे बढ़ गए हो तो बहुत अच्छी बात है. राइट. ओके, so we have a test series also, BYJU'S exam prep test series. You all know about it. We won't waste time. Now, introduction. These are some basic facts. You may just have a look at them. Indian Contract Act was enacted in 1872, came into force on 1st September 1872. Section 2H of the Indian Contract Act defines the term contract as an agreement enforceable by law. Basically, I'll tell you what contract is. Let's not read what is written. Your speed is slow. Sijan, if your speed is slow, there's no solution then to practice. There is no shortcut. Speed अगर slow है तो और कोई तरीका ही नहीं है किसी चीज का. तुम जितना practice करोगे speed बढ़ जाएगी. देखो तुम पता नहीं लगा सकते हो कि तुम्हारी speed बढ़ गई है. करते रहो, लगे रहो, बढ़ जाएगी. ठीक है, और कोई तरीका नहीं है speed बढ़ाने का. आपको AILET ज्यादा easy लगता है CLAT से? Seriously? My God. You might be the first student saying that. मुझे मुझे बिल्कुल भी नहीं अंदाजा कि कोई बच्चा ये भी कह सकता है कि मैम AILET ज्यादा इजी लगता है मुझे क्लैट से, क्योंकि मुझे AILET ज्यादा डिफिकल्ट लगता है क्लैट से. कंपटीशन भी ज्यादा है, प्लस वो एक पर्टिकुलर सेक्शन पे स्टिक करते हैं और उसे ओवर कॉम्प्लिकेटेड कर देते हैं और वहीं से वो पूरा क्रीम चर्न कर लेते हैं. It will be a bilingual class. It will contain both Hindi and English. So basically, let's assume that two parties enter into a mutual understanding where one party promises to do something for the other party. Now, this kind of promise, the promise that both parties made or make to each other is called an agreement. Now, if one of the parties fail to do what they promised or decide not to do what they promised, what remedy does the other party have? Let's say that I promised B that I would paint his house for 10,000 rupees. Now I took 10,000 rupees from him, but I did not paint his house. I did not paint his house. When he started pressurizing me, I said, no, I'm not going to paint. Painting is not my job. I'm a faculty of law. Now, what remedy does he have? What can he do? What do you think? What can he do? मैंने मना कर दिया उसे, मैं पेंट वेंट नहीं करूंगी, मैं लॉ पढ़ाती हूँ, मैं अपने काम को बहुत एंजॉय करती हूँ, पेंटिंग शेंटिंग नहीं करना मुझे. अब वो क्या कर सकता है बेचारा? What remedy does he have? बताओ जल्दी से. What remedy does he have if I refuse to paint his house? He can sue me, right? He can sue me, exactly. But what if he asks me to kill someone? I take the money and then I don't kill that person because my conscience doesn't allow me. And then I say, sorry, bro, I cannot kill. Even though I studied law and I understand how to hide evidences and all of that, but I still do not want to kill somebody. It will weigh too much on my conscience. And he says, fine, I'll hire somebody else, return the money. And I say, no, I already spent it. Now can he sue me? अब sue कर सकता है वो मुझे? Void. So you understand the gist of it, right? Now agreement is there, definitely. But if I do not perform what is written in the agreement and the party gets suffered because of it, and the party can take me to the court, the right that one party gets to sue another party if that party fails to perform the contract or fails to perform what is written in the agreement is called a contract. In simple words, if the piece of paper, that agreement which is written on the piece of paper, can be taken to the court by the party who is claiming that other party is not doing what they have promised to do, and the court can make the other party or compel the other party to do what they promise, that agreement is called a contract. कागज का टुकड़ा agreement नहीं होता, लेकिन अगर एक पार्टी उस कागज के टुकड़े को कोर्ट ले जाए और माय लॉर्ड से कह के दूसरी पार्टी को फोर्स करवा दे कि माय लॉर्ड ये वो काम नहीं कर रहा जो अग्रीमेंट में इसने प्रॉमिस किया था कि वो करेगा और मुझे वो करना पड़े क्योंकि कोर्ट मुझे ऑर्डर दे रहा है, तो वो अग्रीमेंट कॉन्ट्रैक्ट बन जाता है. As soon as an agreement gets a legal enforceability, as soon as the law recognizes its existence, we start calling it a contract, right? So an agreement does not become a contract ipso facto. An agreement becomes a contract only when certain prerequisites are followed. क्या क्या है वो prerequisites? What are the prerequisites that make an agreement a contract? Come on, one by one, hurry up. What are the prerequisites that make an agreement legally enforceable? Mansi, I will answer your question. Give me a moment. Free consent. Sonal says free consent. Are you sure? Okay, so Arya says offer and acceptance. Absolutely correct. Offer and acceptance are in fact the first stages. That's how an agreement starts. There is an offer, the offer needs to get accepted. Then there is an agreement. उसके बाद हम देखेंगे कि बाकी भी है कि नहीं. तो offer and acceptance compulsory है. Then we have lawful consideration, lawful object, free consent, enforceable by law. तो बाद में बनेगा ना. सिर्फ consideration, object और exactly. Now, capacity. Umair, very good. Capacity of a party. What else? Enforceability by law is not a prerequisite. It is not a prerequisite. Prerequisites add होते हैं तब agreement enforceable by law होता है. अपने आप नहीं हो जाता वो. Intention to create legal relationship. Very good. Capacity of the party. Yes. How about certainty and possibility of performance? If a contract is not certain, can it be performed? If the contract is not capable of being performed, can it be performed? So of course the agreement has to start from somewhere. So it starts from offer. The offer is accepted, it becomes an agreement. If there is a consideration in the agreement, इसको stages से लेते हैं. Let's say A offered B to buy his house. A asked B that I really like your house, buddy, will you sell it to me? B says, fine, I'll sell it to you. Now, this offer made by A is accepted by B, right? As soon as the offer is accepted, we call it a promise. Every promise is an agreement. Now, we'll see all the other facets. Do they have a consideration? A says that I will buy your house for 10,000 rupees. This is the consideration. Consideration is basically a benefit that both parties get from this contractual relationship. Now, 10,000 rupees is a lawful consideration. It is an exchange or a benefit which is in the legal tender, which government of India accepts. So this is lawful consideration. The object of the entire agreement is the occupation of a house. Sorry, not occupation of a house. The object of the entire agreement is buying and selling of a house. One would buy a house, the other one would sell the house. So subject matter is house. One would occupy the house, one would vacate the house. So this object is also valid. The object, if the house is used for something which is legal, which law allows, for example, residential, or opening a PG, or opening a hotel, or anything that a person can do which is allowed by law, this should be the object. The object should be legal. If the object is legal, very good. Then, possibility of performance. Can this agreement be performed? Can the promise be performed? I'll give you 10,000 rupees, you give me your house. Very, very much. It's quite capable of being performed. Possibility is there. Certainty, the consideration amount is certain. The house which needs to be bought is also certain. Both parties exactly know what they're doing. One is buying the house, one is selling the house. The amount is certain, their intent is certain. There is certainty. The agreement is now a contract. ठीक है, ऐसे बनता है अग्रीमेंट कॉन्ट्रैक्ट. ये सारे के सारे फैक्टर्स फुलफिल होने चाहिए, वरना agreement enforceable by law nahi hota. The last thing is intention by parties. Now, by getting into this mutual arrangement, did parties really want to give it a legal tone? Like if, for example, A refused to pay money for the house, or if B refused to sell his house, will A want to go to the court, or is B expecting कि भाई अगर मैंने घर नहीं बेचा तो मुझे कोर्ट ले जाएगा? Would B expect that if I don't sell my house, A might take me to the court? Is there an expectation like that? If yes, there was certainly an intention to create contractual obligations, and that is also very important. An informal understanding or an informal arrangement is not a contract. It is just informal. There has to be an intention by the parties. There has to be a knowledge in both parties' heads that in case of failure of performance or in case of breach of performance, one of the other party might take me to the court. Okay, everybody clear? Is there any doubt whatsoever till now? It's not buffering. No, it's not buffering. Agreement of the same thing on same sense. Yes, Vinayak, it's free consent. Yes. Now, these are the essentials. The essential condition of a valid contract are these. What is illegal cannot be a contract. There's section 10 which says what agreements can be contract. So, all agreements are contract if they're made by free consent of the parties. The consent have to be free. Consent has to be free, which means that the consent was not manipulated by any of the parties. I wanted to buy a house. Is it still buffering? Is it clear? Wait, there's a problem. There's a problem. There's a problem. What is happening? I know it's clear, but why do you see my curtains? Completely clear. I'm explaining in all the languages, Kajal. I am using Hindi and English both, sweetheart. हिंदी बोलो तो बच्चे कहते हैं मैम इंग्लिश ओनली, इंग्लिश बोलो तो बच्चे कहते हैं मैम हिंदी ओनली. मैम भी क्या ही करे यार. Completely clear? Yes. Hmm. Okay, so where did the buffer start from? Where exactly the buffer start from? कहाँ से बफर होना शुरू हुआ? मैं तो बोलती रही, मैंने तो ध्यान ही नहीं दिया, बफर होना शुरू हो गया. Yes, I'll continue. So where did the buffer start from? I'll continue from that. We were discussing section 10, right? I'll discuss it again. So all agreements are contract if they're made by free consent of the parties. Free consent of the parties, both parties have their heart and minds both set into a contract. They know exactly what they're doing. Their consent is completely there. They're not manipulated. They're not influenced. Nobody is telling them anything. Nobody is threatening them. They're doing it out of their own free volition or their free will. That is free consent. Competent to contract means they're not intoxicated, they're not insane, and they're not minors. Insanity is not just retardation or a person who is retarded. That, there's a difference between mental age and physical age. That's not just insanity. Insanity has a very wide connotation. So if a person, let's say, suffering from a mental disorder, not if not a mental disorder, but a mental disease such as dementia, Alzheimer's, schizophrenia, or something like that, it is also insanity. Or if a person is suffering from a venereal disease which renders him extremely weak, then also he is considered unfit to contract. Okay. Yes. Now for a lawful consideration, what is lawful consideration? Anything which is legal and can be exchanged. That is lawful consideration. So consideration, I already told you what is it. Consideration is the benefit that accrues from a contract. ठीक है, तो कॉन्ट्रैक्ट में एंटर कर तो लूंगा मैं, लेकिन मुझे मिलेगा क्या? मतलब मेरा क्या फायदा हो रहा है इसमें एंटर करने से? ये फायदा कंसिडरेशन. ठीक है, अब ये फायदा कुछ भी हो सकता है. इट्स नॉट नेसेसरी दैट इट हैज टू बी money. It can be anything, but then it has to be legal. You cannot give somebody marijuana or opium or alcohol and then say, if I'll give you free alcohol if you know sell me your house, or I'll give you a lifetime supply of alcohol if you sell me your house. No, you cannot give somebody alcohol without proper permit and license, right? And giving somebody alcohol cannot be used as a mode of exchange. It cannot be used in barter, so it is illegal. Yep. Lawful object is the purpose of the contract. Now, what is the purpose of the contract? A person is buying a house. I get it. But why is he buying the house? What is the point of buying a house? Is he using it for residence? Is he using it to open a PG? Is he buying it to open a hotel? What is the reason behind buying that house? That is the object. And what is the reason behind selling the house? That is the object. If he is using the house for something which is legal, that law allows, then the object is lawful. But if he's using the house, or if he's buying the house to use that property for something that law does not allow, for example, opening a whorehouse, or opening a gambling center, or opening a smuggling warehouse or something like that, then the object is unlawful. the agreement is void, or if it is not expressly declared to be void. So those categories, no, the agreement which restrain marriage, which restrain trade, which restrain somebody's right to legal uh, proceedings, or a wagering contract, these kinds of agreements are expressly declared to be void. So if an agreement does not fall in any of the categories that is mentioned by section 10, then we say that the agreement is enforceable by law. A person can take that piece of paper to the court and it becomes a contract. How to increase marks in mocks? सारे ही केस में माइनर के साथ अग्रीमेंट वॉइड होगा, किसी भी केस में माइनर के साथ अग्रीमेंट वैलिड नहीं होता. Okay, it is void in all scenarios, in all circumstances. It is void ab initio. So agreement with a minor is void, end of story. There is nothing that can change that. How to increase marks in mocks, can we discuss that later on? We are studying something right now. If you pay attention to what I'm teaching you, you might be able to increase your marks. Okay, today we are going to study offer. Now, what is an offer? Offer is the first step towards formation of a contract. Offer is basically a proposal. So if a person is expressing his desire to do something for the other person, or if a person is expressing his desire not to do something for the person, right? So I'll give you my house, or I want to buy your house, so he wants to buy his house, or any proposal that a person might offer or express is called an offer. Very simple. Even for articles of necessity, in case of that, is also not a contract, that's a quasi contract. That's a quasi contract. Okay. Can minor be sued? Nope. जोया, अगर माइनर ने अपने आप को मेजर प्रोजेक्ट किया है कि मैं मेजर हूं, और सामने वाले ने गलती से उसके साथ अग्रीमेंट कर लिया और बाद में पता चला वो माइनर है, तो भी अग्रीमेंट वॉइड होगा. देखो ऐसा है, बहुत ही सिंपल सी चीज है. इट्स नॉट, it seems unfair. It That is exactly what happened in the landmark authority Mohari Bibi versus Dharmadas Ghosh. So Dharmadas presented himself to be a major. He was not a major, he was a minor, and he took a loan of 20,000, or took a he mortgaged his estate and took a loan of 20,000 back in 1800s. Huge amount and huge estate. So Brahmodas was the person he took a loan from, and he lied that he was a major. Despite that lie, despite the fact that his age was misrepresented, the consent was not free, etc., Brahmodas actually kind of knew that Dharmadas was not a minor, was not a major, but he still went ahead because he thought, I will get the estate for 20,000 bucks. Right, so he will still not be entitled to sue the minor and recover the money. Actually, there is no remedy from the contract. Ordinarily, if there is a breach of contract, you can sue. According to the contract gives you a right to sue. So if a person doesn't performing his end of the bargain, you can take him to the court. That is what the contract entails. But in case of a minor, contract is void. It does not give you any right. It does not give anybody any duty. It's absolutely a waste of paper. But then there is remedy coming from another law, Specific Relief Act, Section 33. So if in case an instrument is declared to be void, or if an instrument is declared to be voidable, any benefit that has been acquired by the person who got that instrument declared void will have to be returned. So if a minor is contesting that I am a minor, the agreement is void, and the court accepts that the agreement is void, the minor will have to return the benefit. The benefit that he took, that's it. No compensation, no penalty, nothing, no jail. The benefit that he took will have to be returned or will be recovered from his estate. तो कॉन्ट्रैक्ट एक्ट से रेमेडी नहीं निकल कर आती है, क्योंकि कॉन्ट्रैक्ट वॉइड होता है, वो सॉरी अग्रीमेंट वॉइड होता है. अब अग्रीमेंट ही वॉइड है, कोर्ट उसके एग्जिस्टेंस को एक्नॉलेज ही नहीं कर रहा, तो फिर रेमेडी कहां से निकलेगी? कोई राइट नहीं, कोई रेमेडी नहीं. देयर इज नो राइट, देयर इज नो रेमेडी. राइट, उबी जस्ट इबी रेमेडियम। लेकिन दूसरा लॉ है जो कर देता है न्याय, इक्विटी के प्रिंसिपल्स हैं ये सारे, डोंट वरी, नोबडी गेट्स सफर्ड। अगर एग्रीमेंट में माइनर बेनिफिशियरी है तो दैट्स अ डिफरेंट थिंग, that's a different thing. He's not a party to a contract. If he's a beneficiary, he can take the benefit. Even in a partnership, minor can become a beneficiary. Partnership is also a kind of a contract act only, like it is kind of a contract act, right? So in a partnership also, a minor can become a beneficiary, but he's entitled to the profits only. He will not participate in losses. So that's how the laws are. You don't have to get into the extreme detail, it's not really necessary. He does not have to repay the money, he'll have to return the benefit if he can. If he cannot return the benefit, nobody can compel him. There is an exception, quasi contract, an arrangement which is not really a contract, but for the purpose of equity, law creates a fiction and declares that instrument to be a contract. So if there is a minor can get into an arrangement of necessary supplies, okay, that is one exception. Is it called the doctrine of estoppel? No, 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 not at all. अभी जो पढ़ा रही हूँ पढ़ ले या नहीं पढ़ना, मतलब वो भी पढ़ सकते हैं, ये भी important है बच्चे. This is also important. Trust me, it is important. माइनर से इतना important नहीं होगा जितना ये important है. Okay. Right, so let's start. Offer. So this is the first step towards formation of a contract. How does an agreement start? When somebody makes an offer. I am ready to do this. I am not ready to do this. So this is an offer and a proposal or an expression of a desire to do something or abstain from doing something. जैसे कि I will not throw garbage anywhere near your house if you promise that you won't throw garbage anywhere near my house. So both are abstaining to do something. This is also an agreement, right? This is also an offer. This is also an offer. Now, how can offer be expressed? It can be expressed by any manner. It can be expressed in words, it can be written, it can be in form of a conduct, it can be in form of an email, anything that signifies somebody's expression. So for example, if I go to a shop, I like a dress, I pick up the dress, I try it on, I pick it up, and I go to the cashier without saying a single word. He immediately bills it without saying another word. So both of us are silent and an agreement and a contract is formed. So I offered to buy that dress at that given price and I did not say anything. Just by putting that dress on the cashing counter is enough to signify my offer. So these kinds of offers are called implied offers. So by conduct also you can express your desire to do something or abstain from doing something. Okay. To another person, the assent of that other to such act or abstinent is said to make a proposal. Now, there are various kinds of offers. What are the kinds of offers? Specific offer, general offer, counter offer, invitation to offer. Now, we'll study them one by one. You have to pay attention. These are important. They have a landmark authority attached to them. These are important concepts. ठीक है, तो instead of asking me questions and interrupting me in between and breaking my flow, I would request you to pay attention. After I'm done with these 4 offers, we can start discussing what all your problems are. Do we have a deal? Do we have a contract? Umair, seriously, buddy. Can somebody answer Umair's question? Deal. So nobody is disturbing me, right? Before we move forward, can somebody answer Umair's question? That's Yeah, that's the difference actually. Very good, Hariom. Very good, Arya. Okay, let's start. Specific offer. What is a specific offer? An offer made to a particular person or a particular group of people. That is a specific offer. So if I want to sell my house to A particularly, I'm not offering my house to anybody else, then this offer would be a specific offer, right? So an offer made to a particular person, a particular group of individuals, like the number and the individuals are determined. जिसको तुम ऑफर कर रहे हो वो पिक्चर क्लियर है किसको ऑफर किया जा रहा है, एक हो सकते हैं, दो हो सकते हैं, 10 हो सकते हैं, लेकिन जितने भी लोग हैं तुम्हें पता है कि तुम एग्जैक्टली किस किस को ऑफर कर रहे हो. इट इज completely clear and specific that the who you are actually expressing your or making your proposal to. That is a specific offer. What is a general offer? General offer basically is not made to a particular person or a particular group of people. It is made to general public at large, and everybody is invited to accept that offer. So that is a general offer. For example, an advertisement of anything. Let's say there's an advertisement or advertisement that is about a certain vacancy in a government department or in a private company. Now all the criteria or all the eligibility or the eligibility criteria is written. You follow, you read the criteria. If you fit the criteria, you apply for the job. As soon as you think that you fit the criteria and you apply for the job, it means that you have accepted the offer. So basically, general offer is, as the name suggests, made to the general public at large. The problem that happened initially when the concept got or started becoming famous was, how does a person know that a general offer is accepted? It is made to a lot of people, right, together. So if anybody of them accepts the offer, how will we know? And communication of acceptance is compulsory, right? If I am making an offer and somebody is accepting that offer, I need to know. वरना agreement कैसा? ठीक है, मैंने तुमसे कहा कि मैं तुम्हारा घर खरीदूंगा, तुमने कहा ना हाँ बोला ना बोला, कुछ नहीं बोला, तो मुझे कैसे पता चलेगा कि तुम मुझे अपना घर वाकई बेच दोगे? नहीं पता चलेगा ना. तो एक्सेप्टेंस का जो कम्युनिकेशन है वो बहुत जरूरी होता है, वरना अग्रीमेंट पिक्चर में नहीं आता, अग्रीमेंट एग्जिस्टेंस में नहीं आता. The initial problem that happened in general offer was this: how will we know that a general offer is accepted? The famous case, Carlyle versus Carbolic Smoke Balls Company. What happened in this case? The smoke ball company released an advertisement saying that we are releasing a pharmaceutical product, a smoke ball basically, and that can cure influenza. If you consume it in the manner we have prescribed, you will not get influenza. But even after the consumption, exactly in the prescribed manner, you get influenza, we'll give you 100 pounds. Right? That was the guarantee taken by the company. And in order to show their sincerity towards their deed, they actually made their bank statement public. They had deposited 1,000 pounds in a public bank and they released that statement along with the advertisement. Now, this lady, Carlyle, bought the smoke balls, consumed them in the prescribed manner, but still got influenza. After she got the disease, she claimed for the 100 pounds that was promised by the company. Now, in this case, the company said, you accepted the offer. How do we know you accepted the offer? We did not know. We made an offer, fine, it was made to the general public, but how did you communicate us your acceptance? हमें क्या पता तुमने ऑफर एक्सेप्ट कर लिया भैया, मतलब तुमने मनी मन ऑफर एक्सेप्ट कर लिया और फिर हम लोग बाउंड हो गए उस पे. ऑफर का एक्सेप्टेंस और या एक्सेप्टेंस का कम्युनिकेशन हम तक नहीं पहुंचा. जब कम्युनिकेशन हम तक पहुंचा नहीं, हमें पता ही नहीं चला तुमने एक्सेप्ट कर लिया, तो फिर अग्रीमेंट कैसा? और जब अग्रीमेंट नहीं है तो कॉन्ट्रैक्ट कैसा? और जब कॉन्ट्रैक्ट ही नहीं है तो हम क्यों तुम्हें पैसे दें भाई? 100 पाउंड कोई छोटा मोटा अमाउंट तो होता नहीं, अभी भी बहुत बड़ा अमाउंट है. अब यहाँ पे बात आती है कि हाउ डज वन एक्सप्रेसेस और हाउ डज वन communicate a general acceptance or a general offers acceptance, right? It's lagging in between. Is it lagging in between really? Very good, Rahi. Whatever your name is, buddy. It's not lagging. Your internet is creating problems. Not lagging at all. Okay, so yes, the court clarified the position. In what manner? That if you are putting forth conditions, a general offer always comes with conditions. It always comes with conditions. You cannot make an offer just like that. You would obviously be imposing a certain condition. Bring your old product, take a new product. Now you always, in a general offer, there's always a condition precedent. You have to do something. Now, if a person is willing to do certain things or is willing to accept your condition precedent and fulfills your condition precedent, it means that he has accepted the offer. और यही तरीका है जनरल ऑफर को एक्सेप्ट करने का. सो वट एवर क्राइटेरिया यू हैव पुट फोर्थ और वट एवर क्राइटेरिया यू हैव लेड डाउन इन योर एडवर्टीजमेंट, if a person fulfills the criteria or does what you have asked him to do, that means he has accepted the offers. You are legally bound in a contract. The moment that lady Carl bought the smoke balls and consumed them in the manner prescribed, she fulfilled the conditions of the offer. As soon as she fulfilled the conditions of the offers, she accepted the offer, and that communication is not necessary in a general offer. Mere following the conditions would be enough, and the company was held to be bound by a contract. Right? Rahi Kapoor. Okay. Do you understand? Did you understand? Guys, everybody, is there a doubt whatsoever? Is there a doubt whatsoever? We still have a lot to go. This is going to be a long class. लंबी क्लास है, ये अभी बहुत पढ़ना बाकी है, उसके बाद तो प्रैक्टिस भी चलेगी. तो अच्छा पानी वानी लेकर बैठो तुम लोगों को लग रहा होगा अरे 9:53 हो गए, 10 o'clock मैम खत्म कर देंगे क्लास. नहीं, 10 o'clock मैम क्लास खत्म नहीं करेंगी. This is called a last lap for a reason. Okay, I'm giving it so much attention and I'm praising it so much for a reason. It is going to be a long class, at least 90 minutes or 120 minutes. इसीलिए पानी खाना सब लेकर बैठिए, आराम से खाते जाइए, पीते जाइए और पढ़ते जाइए. नोट्स भी बनाने हैं साथ में. Okay, can I please repeat general offer once again? Khushi, general offer basically is an offer which is made to a public, which is made to the entire public at large. Right, so uh, it is not pointed towards a particular person. It is not made to a particular person. जैसे advertisements नहीं आते न्यूज़पेपर में, राइट तो पूरी पब्लिक को इंटीमेट कर दिया जाता है कि देखिए ये ऑफर है, इसे आप एक्सेप्ट कर लीजिए. तो जैसे सेल आई है या फिर न्यूज़पेपर में आया कि अपना पुराना प्रोडक्ट लाइए, नया प्रोडक्ट ले जाइए, तो ये भी एक ऑफर है. ये जनरल ऑफर है. जो ऑफर सबको दिया जाता है वो जनरल ऑफर होता है. ओके, दैट इज जनरल ऑफर. Got it? Now we come to counter offer. What is counter offer? Now, one major condition of an offer is that if one expresses or one is proposing something, anybody, a person, if is proposing something, that proposal has to be accepted in that manner only. And acceptance has to be absolute. Basically, what it means, if I'm offering something to somebody, that offer has to be accepted in that manner. He cannot change it. He cannot make me change it. He cannot haggle. He cannot negotiate. He can do no such thing. मैंने जो ऑफर किया है, सामने वाला अगर कॉन्ट्रैक्ट करना चाहता है तो उसे वो ऑफर वैसा का वैसा एक्सेप्ट करना पड़ेगा. उसमें वो कोई चेंज नहीं ला सकता, कोई ऑल्टरेशन नहीं ला सकता, कोई हैगलिंग नहीं, कुछ भी नहीं. जैसा ऑफर तुम्हें मिला है वैसा ही ऑफर एक्सेप्ट करो. That is the condition of the offer, right? So if I make an offer and instead of accepting the offer, another person starts haggling. So let's say that I say I'll sell it for 1,000 rupees and the other person says no, I can buy it for 900. Right. So as soon as that person refuses to buy my item or refuses to accept my 1000 rupees offer and instead presents his own quote of 900 rupees, he has given a counter offer. So an offer placed before an offer is called a counter offer. If I'm making an offer and somebody accepts it, there would be an agreement. But if I make an offer, somebody instead of accepting places his own condition, that kind of offer is called a counter offer. Now, as soon as the person gives a counter offer or starts haggling, my original offer gets nullified. My original offer dies. Now, his counter offer will be the original offer. That's where the agreement would start from. If I accept his counter offer, then it might be an agreement, not otherwise. सिंपल वर्ड्स में अगर मैंने एक ऑफर किसी को दिया है और उसने ऑफर एक्सेप्ट करने के बजाय हैगलिंग शुरू कर दी, ठीक है, और अपना कोई कंडीशन लगा दिया, जैसे मैंने तुम्हें कहा कि मैं 1000 रुपए में बेच सकता हूँ जी, सामने कहा नहीं 1000 रुपए तो बहुत ज्यादा है, 900 में खरीद लूंगी मैं, तो उसने अपनी कंडीशन लगा दी, हैगलिंग बार्गेनिंग शुरू कर दी, मेरा 1000 रुपए का ऑफर डेड है। अब ये उसका जो 900 रुपए का काउंटर प्रपोजल था यही प्रपोजल है, अगर मैंने इसे एक्सेप्ट कर लिया तो अग्रीमेंट बन जाएगा, ठीक है, वरना नहीं बनेगा। अब 900 के बाद वो अगर कहती है कि भाई मैं 900 में ले सकती हूँ और मैं मना कर देती हूँ कि नहीं मैं 900 में नहीं बेचूंगी, और फिर बाद में वो कहती है कि नहीं चलो अच्छा 1000 में ही दे दो, और मैं फिर भी मना कर देती हूँ कि नहीं अब तो मुझे बेचना ही नहीं है, तुम तो बार्गेनिंग क्वीन हो तुम, तो अब वो मुझे कंपेल नहीं कर सकती बिकॉज माई ऑफर इज डेड। आर यू गेटिंग और आर यू गेटिंग कंफ्यूज्ड? Everybody bargains here. Everybody bargains. But the thing is that in a general scenario like these, no counter offers get accepted. Haggling does get accepted. But the thing is that, the agenda behind counter offer is that you cannot compel a person to go back and perform his original offer. That's the entire concept of counter offer. So what I'm trying to say is that let's say that I offer to sell my land at 1000 rupees, which actually happened in a case Hyde versus Wrench. Okay, so Wrench wanted to sell his plot estate and he said that I will sell it for 1000 pounds, and Hyde rejected the offer. Wrench once again said, I am still, the land is still on the market. It's a beautiful estate. You can buy it. The price is not that much. And to that, Hyde said, fine, but I'll buy it for 950, not 1000 pounds. And Wrench declined. Now, after Wrench declined, Hyde had more time to go over the offer and he thought 1000 pounds is not a bad deal. He went over to Wrench again and he said, I accept your offer and I will buy that land for 1000 pounds. Wrench said, I am not selling anymore. Now there was a confusion. You offered to sell your land at 1000 pounds. I am now accepting the offer. You are bound by a contract. That is what happens. एक ने ऑफर दिया, दूसरे ने एक्सेप्ट कर लिया, अग्रीमेंट हो गया, बाकी अगर कंडीशंस फुलफिल हो रहे हैं तो कॉन्ट्रैक्ट हो गया, और कॉन्ट्रैक्ट तो मैंडेटरी होता है। तो हाइड ने यही कहा कि भाई तुमने ऑफर दिया, मैंने हाँ बोल दिया, अभी तुम कॉन्ट्रैक्ट में आ गए हो, अब तुम पीछे नहीं हट सकते, अब तुम बेचो मुझे 1000 पाउंड्स में। अब यहाँ पे कोर्ट इंटरफेयर्ड एंड सेड the moment you said that you are not willing to pay 1000 bucks but you would instead pay 950, you killed the offer of 1000 pounds. The moment a person presents a counter offer, the original offer ceases to exist, it dies. Now there is nothing to accept, it is gone. So if you go back to the original offer and accept that, you are not accepting anything because the original offer doesn't exist anymore. And that's what happened in Hyde versus Wrench. जब हाइड ने कहा कि मैं 1000 में खरीद लूंगा, तो अब वो एक्सेप्ट नहीं कर सकता उसे, क्योंकि एक्सेप्ट करने के लिए कुछ बचा ही नहीं। तो काउंटर ऑफर को एक्सेप्टेंस दिया जाए तब अग्रीमेंट बनता है, ठीक है। काउंटर ऑफर आते ही ओरिजिनल ऑफर खत्म हो जाता है। क्लियर? The actual offeree becomes the offerer. right? The person who was supposed to accept now is an offerer, and the person who was the proposer will now be an offeree. He'll have to accept in order to form an agreement. Is there any doubt whatsoever? Completely clear? Now, invitation to offer. It's very simple. Invitation to offer, let's not get into too much detail. Invitation to offer basically is quotation or telling somebody a price of something. So if I'm quoting a price, or if there is any menu or catalog or anything that tells me a price of an item, it means that the person is inviting me to make an offer on that price. That is invitation to offer. So if I go to a shop, a grocery shop, or a shoe store or a clothes store, and I see items hanging, they are not offering to sell those items. They're actually inviting me to offer to buy those items. So if I go over to a shop, to a clothing store, and pick up a dress, go over to the cashier, it means that I'm offering to buy that dress at the quoted price. If the cashier accepts and bills that item, then there would be an agreement. So offer and invitation to offer are two different things. Mere quoting price or mere telling price or expression of a price, giving or exchanging information about the price of a thing is not offer. It is only an invitation to offer. Like in a mall, like at most places. Okay. Now, what is acceptance? Acceptance is when a proposal is accepted. Very simple. So as soon as the proposal is accepted, we call it an agreement. Now, there are conditions. Acceptance has to be unqualified and absolute, like I told you. There cannot be a counter offer. So the way in which an offer is made to me, I will have to accept the offer in that manner completely. I cannot haggle, I cannot negotiate, I can do no such thing. Yeah, of course. There has to be an intent. Actually, proposal can be, there has to be a vivid intention of making an offer. Okay, so in a clothing store, there actually ऐसा नहीं कि वो बिल्कुल मतलब किसी पीछे पड़े हुए नहीं भाई साहब खरीद लो प्लीज खरीद लो प्लीज खरीद लो. No, they're not doing it. They're waiting for customers. They're sitting in their stores, air conditioned stores, at their comfortable chairs, waiting for customers to come in. They're not really bothered. In an offer, a person has to be actively involved to express his desire to do something. If that is missing, it is not an offer. Okay, so if I walk to the store, try on a dress, and then go to the cashier and get it billed, I had an involvement, I had an active participation. I went to the store, then I tried on the clothes, and then I liked it, and then I go to the cashier. Cashier is not doing any such thing, he's just sitting behind the desk. ठीक है, तो ऑफरर का एक एक्टिव इन्वॉल्वमेंट होता है, एक एक्टिव पार्टिसिपेशन होता है, इसीलिए वो ऑफर कहलाता है, इसीलिए वो प्रपोजल कहलाता है. ठीक है, एक्सेप्टर को तो बस बैठे बैठे हाँ बोलना है, दैट्स इट. Decoration of a thing is called invitation, not decoration of a thing. Quotation of price is called an invitation to offer. Stating price or telling somebody the price, menu can be an offer, a catalog can be an offer, invitation to offer. Right, auction is an invitation to offer. So they're telling you the price, and then you make an offer to buy it at that price or buy at a higher price. So the people sitting at the auction make the offer. The auctioneer is just accepting. Okay. Invitation to offer is considered as proposal. Exactly what I didn't say. There is a difference between invitation to offer and an offer. Proposal and offer are the same thing. ठीक है, प्रपोजल और ऑफर सिनोनिमस हैं, जैसे कि अच्छा और गुड सिनोनिमस है ना, तो प्रपोजल और ऑफर उसी तरह से सिनोनिमस हैं. इनविटेशन टू ऑफर में और प्रपोजल में बहुत डिफरेंस है. इनविटेशन टू ऑफर और प्रपोजल, ऑफर तो अलग अलग चीज. ऑफर का मतलब है मेरी डिजायर कुछ करने की या ना करने की. इनविटेशन का मतलब है भाई साहब आप आइए और आप ऑफर करिए और फिर हम देखते हैं कि हमें एक्सेप्ट करना है या नहीं. ये होता है इनविटेशन टू ऑफर. तो अगर कोई प्राइस टैग है या कोई मेनू है या फिर कोई मतलब कोई सेल बताई जा रही है तुम्हें कहीं पे भी 50% सेल अप टू 50%, तो इसका मतलब है कस्टमर्स को इनवाइट किया जा रहा है कि भाई साहब आओ और देखो हमारे प्राइसेस को चेक करो और तुम्हें एक्सेप्ट, तुम ऑफर करो कि हाँ हमें मंजूर है तुम्हारे प्राइस पे इस आइटम को खरीदना, और फिर हम तुम्हें वो बेच देंगे, फिर हम तुम्हारा ऑफर एक्सेप्ट कर लेंगे। इस तरह से चलती हैं चीजें ये। ओके, नेहा, गॉट इट? डिड यू गेट इट? Hariom, don't answer if you don't know, yaar. That's a wrong answer. Neha, did you get the difference? Oh, अभी समझ आ गया? मैं फिर से समझा देती हूँ, कोई बात नहीं. I didn't know you joined late. Can willingness to sell something be an offer or not? I just said yes. Yes, of course it can be an offer. Okay, willingness to do something is an offer. So doing can be anything. Like I said, देखो ऑफरर जो होता है ना, ऑफरर में ऑफर को कैसे पहचाना जा सकता है कि ऑफर है? अब डेफिनेशन को देखो, विलिंगनेस टू डू समथिंग और एब्सटेन फ्रॉम डूइंग समथिंग, मतलब वो कुछ कर रहा है, उसकी विलिंगनेस है, उसकी इच्छा है कुछ करने की या कुछ ना करने की, और वो इच्छा मैनिफेस्ट हो रही है उसके कंडक्ट में, उसके शब्दों में, तो वो ऑफर ऑफर पता चल जाता है. ठीक है, दैट इज एन ऑफर. Of course, the person who invites to make offers can definitely choose to accept or not to accept. बिल्कुल कह सकता है वो, बिल्कुल. I cannot make him bound in an agreement if he refuses the acceptance or if he refuses to accept. बिल्कुल. Okay. Now, competency to contract. What is competency to contract? A person who has attained the age of majority, 18 and above, a person who is of sound mind, a person who is not disqualified by law or declared to be insolvent or bankrupt. तो ये सारे लोग competent हैं. So sound state of mind is not just insanity, it means everything. You need to be in your senses. You need to know what is happening around you. So intoxication, insanity, everything comes under the state of mind. Your state of mind has to be healthy in order for you to enter into a contract. Another thing is you should not have been declared insolvent or incapable of entering into a contract. So let's say a person goes bankrupt. Now he will have to get his bankruptcy declared so that everybody knows that he's a bankrupt. Nobody can coerce him to pay. Creditors cannot make his life hell. A landlord cannot kick him out of the house into the streets, so that he can still live with dignity. The little shred of dignity that remains, he can still enjoy that. इसीलिए वो अपने आप को बैंकरप्ट डिक्लेयर करवा देता है. जैसे ही एक आदमी अपने आप को इंसॉल्वेंट या बैंकरप्ट डिक्लेयर करवाता है, उसकी कॉन्ट्रैक्ट करने की एबिलिटी खत्म हो जाती है. इंडियन कॉन्ट्रैक्ट एक्ट उसे कॉन्ट्रैक्ट एंड में एंटर करने के लिए इनकेपेबल मान लेता है. If A said he wanted to sell his house in front of B, next day B brought money and said he accepted A's offer. A has not made any offer. Is there any contract? It is uncertain. This agreement will be void due to uncertainty. Who is he making an offer to? Is it a general offer? Is it a specific offer? I will sell my house. To who? Right? So ये तो uncertainty में void हो जाएगा. तुम ऑफर कर रहे हो, किसको कर रहे हो पता भी तो चले. अब मैं सड़क पे खड़ा होकर कहती हूँ कि मैं अपना घर बेच रहा हूँ, ठीक है, अच्छी बात है. किसको बेच रहे हो? हमें बेच रहे हो, पड़ोसी को बेच रहे हो, ताऊ के लड़के को बेच रहे हो, किसे बेच रहे हो? राइट. सर्टेनिटी बताया था मैंने, सर्टेन होना चाहिए सब कुछ. अगर अग्रीमेंट में सारे के सारे टर्म्स क्लियर नहीं है, क्रिस्टल एकदम, तो वो अग्रीमेंट वॉइड हो जाता है. It is not an invitation to avoid. It's nothing. It's uncertain. It's not clear what he's doing exactly. Okay, if I say there is a clarification needed. So let's say that I mention in class, I am thinking about selling my phone. It is only a statement. हर statement को offer और acceptance नहीं माना जा सकता. इस तरह से तो हर statement को अगर offer या acceptance माना जाने लगा तो इस दुनिया में सिवाय contractual relation के कुछ बचेगा ही नहीं, है ना. तो सर्टेनिटी इसलिए इतनी कंपलसरी होती है. सर्टेनिटी के बिना अग्रीमेंट कॉन्ट्रैक्ट बनता ही नहीं है. तो ये अनसर्टेन है. मैं अपने घर को बेचने का सोच रहा हूँ. अच्छा भाई, आप मुझे बेच देंगे क्या? अब यहाँ पे अगर ये चीज क्लैरिफाई हो जाती है, हाँ हाँ मैं बेच दूंगा, तो सर्टेनिटी आ गई. किसी ने कुछ पूछा नहीं, उसने कुछ बताया नहीं, कुछ पता नहीं, अता पता कुछ है नहीं, तो वॉइड एग्रीमेंट. ओके, गॉट इट. अभी क्लियर हो गया? फाल्गुनी, देवव्रता, एवरीबडी. Very good, Ashi. Okay, moving on. Competency to contract. Who is not competent under the Indian Contract Act? A minor is not competent, a person of unsound mind is not competent, and a person who is not disqualified by law. What is free consent? Everybody knows what free consent is. So if a consent is not affected by what? Coercion, undue influence, fraud, misrepresentation, and mistake. So if a consent is free from all these five vices, we call it a free consent. Now, what are these five vices? Coercion is basically threatening something. So if somebody threatens me to harm me, okay, somebody threatens my my body, my property, or somebody related to me, and scares me to do something. He scares me and then compels me into doing something, or he compels me into doing something by scaring me. That is called coercion. तो अगर कोई डरा धमका के कि वो मुझे चोट पहुंचा देगा, मेरी प्रॉपर्टी को चोट पहुंचा देगा, या मेरे किसी रिश्तेदार को या कोई जिसकी मुझे परवाह है उसको चोट पहुंचा देगा, और इस डर से मैं उसकी बात मान लेती हूँ और कॉन्ट्रैक्ट में एंटर कर लेती हूँ, तो ये कंसेंट फ्री नहीं है. मेरे कंसेंट को कोर्स किया गया है. दिस एक्ट इज कॉल्ड कोर्जन. Class is going to be long. Silence is considered as acceptance. Neha, do you remember the case of Feldhaus versus Bindley? I taught you. Have you read that? It's past your bedtime. You sleep at 10. That's a very good habit. So I cannot end my class in the middle because it's past your bedtime. No offense. So you can watch the class later. I mean, it will continue. It will be there on YouTube. So that's absolutely fine. Everybody who wishes to sleep can go to sleep. I will end the class. I will complete it. And it is going to be a long class. I told you it might be 90, 100 minutes class. Silence is absolutely nothing. Silence का मतलब है कुछ नहीं. Silence is neither yes nor no in Indian Contract Act. You have to express your acceptance by some manner or the other. Merely accepting it in your head is not acceptance, Neha. Feldhaus versus Bindley. In that case, it was said, it was declared by the House of Lords that if you are accepting an offer, you need to let that person know that you have accepted it by some way or the other. If you cannot say it in as many words, you have to express it by conduct. For example, if I make an offer to somebody that I will buy your house if you add third floor on it, and he immediately starts working on the third floor the next day, it means that he has accepted my offer, right? So he has accepted my offer and he is expressing his acceptance through conduct. So acceptance has to be communicated in one way or the other. Keeping it in your head in a safety deposit box or keeping it a secret is not enough. It will not amount to anything. Neha, in what questions the questions are wrong, sweetheart. No, silence is nothing. अभी क्या कहा मैंने, साइलेंस का मतलब है कुछ नहीं, ठीक है। साइलेंस का मतलब ना तो हाँ है और ना ही ना है, राइट। आप चुप रहकर, मैं सोच रहा हूँ कि तुम्हें अपना घर भेज दूं, क्या तुम मेरा घर खरीदोगे, और मैं कहती हूँ। अब उससे क्या मतलब, साइलेंस से कैसे पता चलेगा कि उसने एक्सेप्ट कर लिया है ऑफर? साइलेंस ये, अगर ना नहीं बोला तो हाँ भी तो नहीं बोला, हाँ नहीं बोला तो ना भी तो नहीं बोला, तो ऐसे नहीं होता है ये। अनसर्टेनिटी पे इंडियन कॉन्ट्रैक्ट एक्ट काम नहीं करता है। वी आर नॉट, इट्स नॉट अ लव ट्रायंगल, इट्स नॉट अ बॉलीवुड मूवी। Okay, it's law, it's a legal instrument. There has to be utmost clarity. So if you're saying yes, you have to make sure the person knows you're saying yes. If you're saying no, you have to make sure that the person knows you're saying no. So silence amounts to nothing at the end of the day. So if I give 7 days to an individual to accept my offer, and at the end of 7 days he says nothing, the offer is dead. I will assume that he has rejected the offer. Okay? Yes. Now, everybody understands coercion. समझ गए तुम coercion क्या होता है? So if I, let's say that A wants to buy, or A really likes B's dress. Okay, B has this beautiful dress and A really likes it. It's new, and she offers to pay her double the amount of that dress. And the lady says, no, I got it from my brother's wedding. I'm not selling it to you. Now she threatens him by a hockey stick. I'll break your bones if you don't give me that dress. Now, in this scenario, she's coercing her, she's threatening her physical being, she's threatening her body, right? She's threatening to hurt her if the dress is not given to her. This is coercion. Okay. Then we have undue influence. What is undue influence? Undue influence is basically using your using your position to emotionally manipulate somebody. So if there's a relationship in which one of the persons or one of the party can emotionally manipulate the consent of another party and then make him enter into a contract, it will be undue influence. Okay, for example, let's say A wants to buy B's house. The house is out of his budget. A's sister is B's girlfriend. So he tells his sister to, manipulate her boyfriend. And she does that. Can you please sell your house to my brother? Come on, baby, please, darling, this and that. Now he can do this for his loved one. And he gets manipulated. She'll become happy. I want her to be happy and this and that. So if you can emotionally manipulate a person, we call it undue influence. And that also makes a contract voidable. The other thing is fraud. What is fraud? Lying, basically. So if you don't tell somebody the right thing, or if you lie to some person, or if you hide something, you actively hide something, actively conceal something, not because you didn't want to or not because you didn't know. You actively hid it from a person, or you lied to a person intentionally so that you can make him enter into a contract. That is called fraud. Basically, किसी को धोखा देना, किसी को बेवकूफ बनाना, झूठ बोलना, बातें छुपाना, इंपॉर्टेंट बातें छुपाना, ताकि सामने वाला कॉन्ट्रैक्ट में एंटर हो जाए, इसे फ्रॉड कहते हैं. Sijan, even in that case, it will not be a contract. It will still not be a contract. If you say nothing, I'll assume that you have accepted the contract. No. In this situation also, you have to express your acceptance. It doesn't work like that. It is forcing a person to enter into a contract. What if a person forgets? Oh, you are bound by a contract. No. Acceptance has to be vivid. Okay, right. Now everybody understand what fraud is? Misrepresentation. What is misrepresentation? Misrepresentation basically is exaggerating something or presenting something to be a little more than what it is actually. So you know the ad of Bonvita or Complan. So the Complan projects that the product is so great that a person would grow up to be a khali. Now a mother gets misrepresented by the ad and starts feeding her son Complan all the time. Breakfast Complan, dinner Complan, lunch Complan. He opens his lunchbox, there's Complan in it. Eat Complan through spoon. Eat your roti with Complan. Whatever you do, just eat Complan. She wants him to grow into 6, 7. Now, generally in this scenario, this is what misrepresentation is. So if you are, if you are telling somebody, or if you are exaggerating a certain thing and a person actually believes you is misrepresented, like the ad of advertisement of Tide. So they, the Tide moves over a shirt and the shirt starts glowing. I mean, it's not even a shirt anymore, it's a freaking tube light. Right now, in that situation, it is they're actually trying to sell their product. They're trying to tell you that their product cleans your clothes. But some people might actually believe that it turns a piece of cloth into a lamp, and in that impression they buy the product. They are misrepresented. ओके, तो अगर कोई एक चीज को बढ़ा चढ़ा के बताता है बस इसलिए ताकि उसकी चीज बिक जाए, तो उसे हम मिसरिप्रेजेंटेशन कहते हैं. Yep, unintentionally. So in the fine line between fraud and misrepresentation is the intention to deceive. In fraud, there is an active intention to deceive. Like a person actively is lying. He's actually not telling you the truth. He's lying. He's telling you something where it does not exist, like at all. Complan is not bad. It does contain certain nutritions, but you have to balance it or complement it with other dietary needs. Complan alone is not sufficient. Similarly, Tide will not turn your product into a lamp, but it will clean your clothes. So if people can understand it, people can understand the exaggeration and the scheme of advertisement, they will not get misrepresented. But if people actually do get misrepresented, then the contract becomes voidable. Now comes our another question. What is voidable? क्या है voidable? So an agreement is void, which means that the agreement is not recognized by in the eyes of law. Law does not acknowledge the existence. Law does not acknowledge the presence. Whereas voidable is something wherein the contract is valid but can be declared void also if one of the parties' consent is not free. So the party whose consent was manipulated by fraud, misrepresentation, coercion, undue influence, or mistake, then they can choose. They can follow or stay in the contract, or if they can get out of the contract. और ऑर्डिनरीली अगर तुम कॉन्ट्रैक्ट से बाहर निकलना चाहते हो तो तुम्हें कंपनसेशन देना पड़ता है, क्योंकि अगर तुम बाहर निकलते हो कॉन्ट्रैक्ट से बीच में तो तुमने कॉन्ट्रैक्ट ब्रीच कर दिया. ठीक है, तुमने कॉन्ट्रैक्ट को वायलेट कर दिया, अब तुम्हें कंपनसेशन देना पड़ेगा. वॉइडेबल कॉन्ट्रैक्ट में तुम्हारे पास चॉइस है. अगर तुम्हारा कंसेंट फ्री नहीं था तो तुम चाहो तो कॉन्ट्रैक्ट परफॉर्म कर लो, लेकिन अगर तुम चाहो तो कॉन्ट्रैक्ट से पीछे भी आ सकते हो. You can choose not to perform also. So if a valid contract can turn into a void contract, we call it a voidable contract. Okay? Is child marriage void or voidable? It's illegal, Kaveri. Hindu marriage is not an agreement. Muslim marriage or nikah has a force, or the procedure is like that of an agreement. So in Muslim nikah, child marriage is voidable. It is. But in Hindu marriage, it is not voidable. Okay. Now we understand this fraud, misrepresentation, and everything. What is mistake of fact and what is mistake of law? Mistake of law basically when somebody doesn't understand the law. So let's say that a person comes from Amsterdam where marijuana is legal and starts smoking marijuana right here in the middle of the road in New Delhi. And a police officer arrests him and he says, marijuana is illegal in your country. I didn't know. I mean, it's legal in my country. So this lack of knowledge or this ignorance, lack of awareness will not save him. So even if he doesn't know law will not exempt him. Mistake of law is not a defense, but mistake of fact is a defense. So for example, if I assume or if I take somebody's dog My dog is playing around with a lot of dogs. Now it's not exactly daytime, it's almost night. I am in a hurry. I take my dog, come back to my house, and I notice that it is not really my dog, it is somebody else's dog. Now this is a mistake of fact. I mistook somebody else's dog for mine क्योंकि अंधेरा हो रहा था, और जो डॉग मैं ले आई अपने घर पे वो बिल्कुल मेरे ही डॉग जैसा था, दोनों बिल्कुल जुड़वा भाई थे, और ये गलती किसी से भी हो सकती थी। तो अगर आप इस तरह की कोई गलती करते हैं, वो गलती जो एक रीजनेबल आदमी से हो सकती है, तो आपको बेनिफिट ऑफ डाउट दे दिया जाता है एंड यू कैन गेट आउट ऑफ अ कॉन्ट्रैक्ट. Mistake of law is not a defense. Now, lawful consideration, we have already discussed lawful consideration. Let's discuss what kind of considerations can be there. Consideration can be, just give me a second, guys. Take a 2-minute break. I'm tired of speaking. Mistake of Indian law is not a defense, while mistake of foreign law is a defense. Oh no. Mistake, actually, it is an impact that it leaves. So mistake of Indian law, it uh, does not do anything to a contract. Okay, so contract remains a contract. An agreement remains a contract if it is a valid contract. If it is a mistake of Indian law. But if it is a mistake of foreign law is considered to be a fact. Okay, so if there's a mistake of foreign law, the agreement is void. It does not become a contract. Yeah, complaint break. So you can ask your doubts. You can ask your doubts. Anybody, any doubts? Nobody, any doubts? Yeah, I don't have water right now, but I'm taking a break, a small break. Okay, let's start. Now, consideration basically is of three kinds: past, present, and future. We know what consideration is. So, past consideration is something that has been promised in past. For example, let's say that, I have helped somebody. I helped somebody, and due to that help, that person promises to do something for me in the future. Now I have already done something for that person in the past. Let's take an example. Let's say that I render a legal counsel to a person. Okay, that person is an owner of a beauty salon. Okay, now because of my past legal counsel, she offers me the beauty services for free in future. अब मैंने पास्ट में ऑलरेडी उसके लिए कुछ कर दिया है, इसीलिए वो मुझे फ्यूचर सर्विसेज फ्री दे रही है. मतलब प्रेजेंट में अगर मैं उससे कुछ करवाती हूँ तो वो मुझसे पैसे नहीं लेगी. क्यों? क्योंकि मैं पास्ट में उसे फ्री लीगल काउंसिल दे चुकी थी. इसे पास्ट कंसिडरेशन कहते हैं. प्रेजेंट कंसिडरेशन वही है, मैं 10,000 में पेंट कर दूंगा, आप 10,000 रुपए में मैं पेंट कर दूंगा, या फिर मैं तुम्हें 10,000 रुपीज दूंगा, मेरा घर पेंट कर दो. तो अभी की जो कंसिडरेशन एक्सचेंज होगी वो प्रेजेंट कंसिडरेशन है. Misrepresenting can be an offense. No, Vinayak, misrepresenting is not an offense. Difference between mistake of law and mistake of fact. Mistake of law is when you do not know the law, when you mistook the law, right? So let's say that people enter into an agreement that, we will, like the thing that I said, that a person comes back from Amsterdam and he starts smoking up marijuana in the middle of the road. Police officer arrests him and then he says, marijuana is not legal. Why are you arresting me? Marijuana is legal. He says, no, marijuana is not legal in our country. So this is an ignorance of law. He did not know. He assumed that marijuana is legal in my country. It might be legal in other countries also. So that is where he will not get the benefit of doubt. He will be punished. He will be taken to jail. Okay, so mistake of law does not affect the contract. That is what I'm trying to say. If you make a law, if you make a contract wherein you did not know the law, you would still have to go ahead with the contract because it doesn't leave an impact on the contract. But mistake of fact, for example, let's say A says that I will sell my house that is there in Rajendra Nagar. Now, A has two houses in two Rajendra Nagars. One house is in Patna Rajendra Nagar and one house is in Delhi Rajendra Nagar. B thinks that he's selling that Delhi wala Rajendra Nagar house and he says yes to this offer. This is a mistake of fact. This is a mistake of fact. They did not have a clarity on which house was on the market. Okay? Yep. Is the difference clear, guys? The one who is giving the offer should have mentioned the house location. Yes, exactly. So mistake of fact renders an agreement voidable or void. So there is again a catch here. If it is a mistake that is made by both parties, it is a bilateral mistake, then the agreement is void. But if it is a unilateral mistake and it can be rectified, then the contract is voidable. For example, my mother tells me that my A's mother asks him to get coconut oil. ठीक है, ए की माँ उससे कहती है जाओ नारियल का तेल ले आओ. वो एक सामने वाली शॉप पे जाता है जहां पे ऊपर बड़ा बड़ा लिखा है हम सिर्फ ऑलिव ऑयल बेचते हैं, और वो जाके कहता है कि अंकल जी 1 लीटर तेल दे दीजिए. अब अंकल जी सिर्फ ऑलिव ऑयल बेचते हैं, इन जनाब ने पढ़ा नहीं, ऑलिव ऑयल लेकर आ गई है, इनकी माँ कहती है ये तो नारियल तेल नहीं है, ये तो ऑलिव ऑयल है. ठीक है, तो यहाँ पे ये यूनिलैटरल मिस्टेक है, लड़के ने मिस्टेक करी है, ये गलत दुकान पे चला गया. तो अब अंकल पे डिपेंड करता है कि वो तेल को वापस ले लेते हैं या नहीं, कि चलो कोई बात नहीं तुम पैसे वापस ले लो तुमसे गलती हो गई, या फिर वो मना कर देते हैं, नो रिटर्न्स नो एक्सचेंज. दैट इज अ unilateral mistake. Okay, present consideration clear. Now we have future consideration. When consideration is paid after making the contract, very easy. So you all the contracts basically are based on future considerations. There are very less contracts जो present पे या past पे based होते हैं. जैसे कि let's say there's a house that I take on rent, that is based on present consideration. I have to pay first, right? I have to pay first in order to get the house. Similarly, if I buy a product, I have to pay first, otherwise they won't give me the product. But if I'm taking a service, for example, like going to a hospital, if I'm going to a beauty salon, if I'm going to any such place which offers services, they'll give me a service first and then they'll take the money. So that is future consideration. If I get a haircut and then I pay thereafter, that will be a future consideration. Yep. Lawful object, you already know. Consideration as well as the object of the contract has to be lawful. Consideration and object are unlawful when they're forbidden by law, when they defeat the provision of any law, when the object is fraudulent, or it involves or implies injury to person or property of the other. It is an immoral agreement. It is opposed to public policy. So these are the factors that make an object unlawful. Okay, now the last is must not be declared expressly void. Yes, so these are the agreements that are expressly declared void, okay, which law does not allow. uh, Law does not allow. Simple. So the first agreement is when the consideration or object is lawful or partly unlawful. Sorry, consideration or object is unlawful or partly unlawful. Or the agreement is made without consideration. Or if the agreement is in restraint of marriage, the agreement is restraining trade, or the agreement is restraining legal proceedings. What is an immoral agreement? An agreement based on an immoral object, something which is opposed to morality. Now, morality has a very subjective connotation. So, let's say that an agreement is done to sell somebody. That is immoral and that is also forbidden by law. So, if there's an agreement to buy a child or to buy a woman or to sell a woman or to sell a child, right? So, it is not only illegal, it is also immoral to sell a human being, right? Yoga immoral. Without consideration, the contract is void, but exception is given. Actually, without consideration, there are three exceptions. There are three exceptions. If an agreement is done, or if people enter into an agreement out of natural love and affection, like I'm giving something to somebody because I have a natural affection for the person. So I may choose not to take anything from him, right? So that is where the agreement will still be valid, okay, in gifts. Or if in past consideration also the agreement is valid without consideration. So for example, let's say that I offered a counsel to somebody in the past, and in the present she's giving me free services. Now she's not taking anything. The agreement has to be void. अगर वो अगर वो मुझसे बाद में पैसे लेती है और मैं कहती हूँ पैसे क्यों ले रही हो तुम, हमारे बीच में तो अग्रीमेंट हो चुका है, और वो कहती है नहीं नहीं कोई अग्रीमेंट नहीं हुआ है, आप कंसिडरेशन जब तक नहीं दोगे अग्रीमेंट नहीं होगा. तो यहाँ पे पास्ट अग्रीमेंट, पास्ट कंसिडरेशन इस अग्रीमेंट को जिसमें कंसिडरेशन नहीं जा रहा वैलिड बना देगी. The fact that I gave free legal counsel to her in the past will make this present agreement legal. Okay? Yep. Must not be expressly declared void. So these are the agreements which are expressly declared to be void. वो agreements जिनकी consideration या object unlawful है, चाहे आधा चाहे पूरा. The agreements which are without consideration, there are three exceptions. One, if the agreement is made out of natural love and affection, the consideration is overlooked because of love and natural affection, then the agreement is valid. But that kind of agreement has to be in writing, it has to be registered, and the relationship has to be close. Otherwise, it is not valid. Second, when there is a past consideration and in the present there is no consideration, then also that agreement is valid. Right? Restraint means something that stops you from doing something. That is a restraint. Okay. Then agreement in restraining of marriage. So if there is an agreement which stops somebody from getting married or which puts an interference in somebody's right to get married, which is a freedom guaranteed under Article 21, then that agreement is also void. If somebody is restraining somebody's right to practice trade, again a fundamental right guaranteed under Article 19, then that agreement is void. If there is an agreement which restrains somebody from instituting a suit, अगर कोई मुझे रोक देता है अपने ग्रीवेंस को एड्रेस करने से या कोर्ट में केस करने से कोई अग्रीमेंट, तो ये अग्रीमेंट भी void होगा. If the agreement is unmeaning, it has no meaning whatsoever, nothing conclusive can come out of it, then that agreement is void. For example, A buys B's car and tells him that I'll give you more 10,000 extra if the car turns out to be lucky. Now what does lucky mean? Lucky is a very subjective term. कार किस तरह से lucky है भाई? तो ये एक बहुत अनसर्टेन चीज है, लकी का मतलब ही नहीं पता, और ये चीज इस अग्रीमेंट को void कर देती है. Yes, you have successfully completed these minutes. Wagering agreements basically are betting agreements in which there there are parties who are betting against each other, and these agreements are void because they're based on an uncertain event. Like I told you, agreements में या Indian Contract Act में, Indian Contract Act does not allow uncertainty in any manner whatsoever. So anything which is causing uncertainty is not allowed. Betting is uncertain. Betting is based on an event which is uncertain. So any scope of uncertainty will render an agreement void. So if I'm betting upon an uncertain item or an uncertain event whose happening and non-happening is both 50-50, then that agreement is void. Okay. But if I'm betting on an activity which is not based on luck, the happening of which is not based on luck, but skill is required, then that agreement is not void. Yeah. Wagering agreement is a complicated topic. Understand it. Okay. Try and understand it. Sorry. मैराथन हो गया ये तो नहीं. Yes. So what is a wagering agreement? Betting agreement. So let's say A and B enter into a contract. A says, I'll give you 10 bucks if it rains. You give me 10 bucks if it doesn't rain. They both agree. Now their agreement or the betting or the agreement is based on an event जो किसी के हाथ में नहीं है. बारिश होती है या नहीं होती है, दोनों पार्टीज के हाथ में नहीं है, इसलिए ये agreement void होगा. For water, I have to end the class. I'm okay, don't worry. I generally start coughing if my hands are exposed. I'll be fine. Don't worry. Right, yes. So this agreement is void because it is based on an uncertain event. But let's say I placed a bet on a game of Ludo. Now Ludo is not uncertain. If I win it, let's say that I bet 50 rupees on it if I win. And the one who loses will have to give me 50 bucks. Now, this game is not based on an uncertain event, or my winning, his losing is not uncertain. It is not unpredictable. I can win if I know the game. He can win if he knows the game. Here, skill is required. तो अगर आप एक ऐसे इवेंट पे बैट करते हो जिसका हैपनिंग और जिसका आउटकम तुम्हारे स्किल पे डिपेंड करेगा, तो ये अग्रीमेंट वैलिड हो जाता है. अगर एक इवेंट का आउटकम किसी चीज पे डिपेंड नहीं कर रहा, बिल्कुल फेट पे डिपेंड कर रहा है, लक पे डिपेंड कर रहा है, तो वो अग्रीमेंट वॉइड हो जाता है. ओके, राइट. Test series we have already discussed, mock test we have already discussed. Now let's practice passages. Come on guys, we'll do as many as we can. Drink Complan. Yeah. Yes, you don't have as much time. Please read. Exactly, Shubham. Like Dream 11 is skill based. उसको जीतने के लिए स्किल की जरूरत है, इसलिए वो अग्रीमेंट या वो बेटिंग वैलिड है. Yep. Now you can see the screen. Yeah, good. I'm still on the screen, right? How do I move? I don't know. Wait, let me try. Let me try. Better? Yep. I already did it. Done. Good. Moving on. Abandonment is to leave something or an act of leaving. That's abandonment. Like not doing something or quitting. Abandonment. Material alteration is a significant alteration. For if a change is noticeable, like a change changes the entire picture, right? For example, let's say that there is a movie that you are seeing or watching. You're watching a movie in which the character is Rishi Kapoor, and then suddenly the same character is played by Paresh Rawal. Now this is a material alteration. People would notice it. That is a material alteration. It is going to continue for every topic, Khushi. It is a series. The sessions will happen every day, sweetheart. Don't worry. You have a session tomorrow also, and tomorrow we have criminal. So you know how what kind of a storyteller I become when it is criminal law, right? So be ready for the story revision or a story like revision. Okay, I was supposed to change it. What am I waiting for? I'm standing for so long, my teeth have begun hurting. Tomorrow, criminal law. Yes, criminal law. इस बार के क्लैट में कॉन्ट्रैक्ट आए ना आए टॉट और क्रिमिनल आएगा और अच्छे से आएगा ऐसा मुझे लगता है मैं गलत भी हो सकती हूँ आई माइट बी रॉन्ग आई एम नॉट गॉड आई एम एन ऑर्डिनरी टीचर राइट सो Pallavi 100% it will help you crack the exam. I have covered at least 70% of the contract guys. मैंने 70% contract cover कर दिया इस क्लास में ये 70% तुम्हें लग नहीं रहा होगा कि मैम 70% है 70% are you serious are you for real I'm not lying guys I have actually covered 70% contract इतना बहुत है तुम्हारे लिए इसी को कर लो बार बार इसी में हो जाएगा काम okay question number 1 A enters into a contract with B to paint certain parts of B's house due to the arrival of unexpected guests. B forgets to mention to A the places in which his house requires painting. As a result, A did not perform his part of the contract. B files a suit against A for non-performance. Decide. That's so sweet, Azad. Thank you so much, buddy. A, Paka. A actually seems logical, doesn't it? It is A. Very good. Yes, it is A. It's very easy. Come on. A is a renowned singer who enters into a contract with B, the manager of Rosemary Theatres. The contract states that A will sing at B's theatre twice a week for the next 2 months, in return for which B will pay her 6,000 rupees. At her first performance, A felt that the payment is not at par with the market standards and her popularity. As a result, she decides to willfully absent herself from the theatre. The guests who arrive for live music ask for their refunds, resulting in losses. As a consequence, B rescinded the contract with A. Decide whether B can claim compensation for the damage incurred due to non-performance of A. तुमने पढ़ लिया, मुझे देर लग गई. B is entitled to claim compensation. अच्छा, for the damage which he has sustained. Okay, 2 is also A. You answered even before I finished reading. Great people. Amazing. The correct answer is yes. Very good. Very good. What do you understand by the term quantum merit? Three. Now three. Khushi says B. 3A. Again A. As much as deserved. D नहीं हो सकता. Can it not be D? Why do you think it cannot be D? A. Everybody says A. As much as deserved. You are not right. I told you. I asked you. D नहीं हो सकता. D भी हो सकता है यार. Work, labor, everything means the same thing. Come on. As per the quantum merit means merit as per the quantity, right? So you would get as per your standards and or what you have done. So it can be work, it can be labor, all of the above is correct. Come on. So less. Nobody said D. C and D are different. B says work done where no price is agreed. C says labor performed where no price is agreed. They're not exactly the same. The words are changed. The correct answer is D. Okay. Yes. Enters into a contract with A to cut branches of the trees in A's garden, lock the main door of the house, could not find a way, etc., etc. You read it, you answer it. I'm done. Is A entitled for compensation? Is A entitled for compensation? Everyone? C. You're saying C. A is not liable to be compensated because he neglected to afford B reasonable facilities for performance of his promise. Okay. When I say that it's D, he is not liable to be compensated because he should have inquired where B can climb tree before hiring him. Okay. It is C. It is actually directly related to the passage. The passage is explaining this to you. यही तो समझा रहा है passage. ठीक है ना? Good. Oh no. What do I do? Wait, I'll hide myself. That is the best way. Now you can only hear me and not see me. But I can see you. Sorry for disturbing. Are you all done? You're taking way too long, guys. What happened? D. Completely sure. Everybody D. D, 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 D. Well, the correct answer to this is B. Sorry. It's B. Come on, yeah. What is wrong with you? B is not liable. He refused to continue unless reciprocal promises are performed by A. It's B. Cannot be B and C. Right? Yes. Moving on to our next passage. That's okay. 4 out of 5. Not bad at all. Because D doesn't correspond to the passage, Priyanka. Because C doesn't correspond to the passage. B is the option जो कि passage से सबसे closely relate कर रहा है. देखो प्रॉपर लग रहा है, बिल्कुल मैं समझती हूँ वो प्रॉपर दिख रहा है, लेकिन वो पैसेज से कॉरेस्पॉन्ड नहीं कर रहा. जब तुमको लगता है कि भाई दो पैसेज दो ऑप्शंस बिल्कुल एक से हैं, तो ये देखो कि पैसेज में कौन सा ऑप्शन दिया हुआ है, विच इज द मोस्ट और विच इज रिलेटेड टू द पैसेज closest, or which is closest to the passage. That is the correct answer. In that question, the option B was the closest to the passage. You can, after the class is over, read the passage again, pause कर करके पढ़ लेना, फिर देख लेना B क्यों निकल कर आया. ठीक है? Done? Moving on. I'll tell you what pawner and pawnee is. Let's say that I need money. Okay, I need money and I don't have money, but I have gold. So I go to a person, I give him my gold, and he gives me money in exchange of gold. So the arrangement is that I am taking a loan on my gold. Okay, I'm pawning my gold jewelry for money. So the moment I'm able to pay him back, I will give him the money and he'll return me my jewelry. So the person now can you tell me? Now can anybody tell me the difference? This is pawning or pledging. अब कौन हुआ पौनी और कौन हुआ पॉनर? पौनी एंड पॉनर. सिंपल सी बात है, बेलर और बेली वाली जो ज्वेलरी को रखवा रहा है वो पॉनर है, और जो ज्वेलरी को रख के पैसे दे रहा है वो कौन है? वेरी गुड सृष्टि, चलो आगे बढ़ जाते हैं। वेरी गुड देवदत्ता, यस। हैट्स ऑफ टू यू गाइस, आई मीन हैट्स ऑफ टू यू। एक बार सब अपनी पीठ थपथपा लो, चलो मेरी तरफ से सब अपने आप को शाबाशी दे लो, शाबाश। ये है तुम्हारी डेडिकेशन, और यही डेडिकेशन तुमसे क्वालिफाई करवाएगी क्लैट, सुनहरे अक्षरों में लिखा जाएगा तुम्हारा नाम। ठीक है, इसी को डेडिकेशन, यही पे नजर आ जाता है कि एक स्टूडेंट कितना सिंसियर है। मैं पढ़ा रही हूँ तो तुम पढ़ भी तो रहे हो, मैं 2 घंटे से पढ़ा रही हूँ तो तुम 2 घंटे से पढ़ भी रहे हो। वो will bear the sweetest fruit imaginable. So amazing guys, very good, shabash. Done. Oh, oh sorry. Not difficult, very easy actually, बहुत easy है, बहुत easy है। अब देखो, अगर पैसेज में इस तरह के पॉइंट्स आ जाते हैं ना, तुम्हारी सबसे पहली रिस्पॉन्सिबिलिटी है पॉइंट्स को अंडरलाइन कर देने की, एक आध क्वेश्चन लग जाएगा इनमें से। You have classes for other subjects, you have classes for all the subjects like these every day till 30th. Okay, done. Anushri, my pleasure, sweetheart. This is why the series has been launched. We understand the requirements of students. मैं समझती हूँ कि कुछ बच्चे अभी से प्रिपेयर करना शुरू कर रहे हैं, आप इस सीरीज पे रिलाई करिए। जितना मैंने पढ़ाया है, जो कंसेप्ट मैंने बहुत डिटेल में नहीं भी पढ़ाया है, वही आपको खुद पढ़ लेने हैं, हो जाएगा क्लैट में। ओके, क्वेश्चन नंबर 1। A pledges his watch with B for a sum of rupees 2000. B keeps the watch in his garage where it is damaged due to rain. चलो पढ़ लो, अब I cannot speak anymore. Okay, so I need to make myself disappear because I am cutting the screen. 6th C completely. Are you completely sure? Let's say. Very good. 6th AC, congratulations. You will seat in a national university. Very good, guys. C is absolutely correct. Question number 7. A pledges his car with B authorizing him to use the car for his personal purposes. One day B was unwell, hence he asked his wife C to drive the car, pick up the daughter D, while returning, loses control, gets damaged, etc. etc. Some say C, some say B. You really think C will have to compensate? C will have to compensate. A files suit of recovery from B. Will B have to compensate or not? Of course, B has to compensate, guys. It is his wife who was driving the car, right? So, husband and wife, it is his children who were there in the car. It is his wife who was driving the car. The damage has happened. The damage has happened. B is liable. Very, very simple. Question number 8. Pledges was to be a security against 4,000. Amount was agreed to be repaid in 2 months. Failed to repay within 2 months. B proceeded to sell the watch. A now wants to redeem his watch. B refuses, stating that the time period has elapsed and the contract between them has expired. Decide whether A can redeem this watch in this situation. Oh, B. A can redeem his watch. Did you read the passage properly, everyone? I just have Khushi and Anushri who is answering me right. Guys, remember the passage. He can redeem it. Passage के साथ साथ दिया गया है. A can redeem his watch even after the expiry, but before B sells it. After paying for the expenses incurred by B in the safekeeping of the watch. It is given in the passage, everyone. Only two answers right. Khushi and Anushri. सबने सी cannot redeem his watch, cannot. इसीलिए पैसेज को ध्यान से पढ़ना पड़ता है बच्चों. Alfia, very good, very good. All the girls, boys also now. You guys are the sweetest. Okay, so A places watch to be as security for a debt against 4,000. Arya also right. Asya also right. Alfia is also right. Anushri is right. And Khushi is right. Who else? Now answer 9. Is A liable to pay 1,000? When I say 9, it's C. Hariom says it's B. Sakshi also says it's C. Arya says it's B. Priyanka says it's A. Priyanka Behra says it's A. Claudia. Don't spam, don't spam. Sujan says it's A. Devanshu, B or C confusion. It's B, everyone. B. C will have A is not liable to pay 1,000 to B. It's B. Okay, question number 10. This is the last question of our session. When can the pawnee recover the difference in the price of pawned goods sold and the amount of the debt owned by the pawner? When I say it's A. Fareen, yes. Yes, there will be. There are 25 sessions, of course. One session for each. When I said it's A, everybody else is saying C and B. Anushree says A. Who else? Guys, it's A. It's A. When after the default in payment by the pawnee, the pawnee sells the goods and get a lesser amount. So it's A, everyone, come on. Right, so that is the last question of the day. Now I think you need to see me all since we are done. Yep. So these are our upcoming sessions. November 6th, we are doing criminal tomorrow. On Monday, Abhimanyu sir would be covering current affairs from January to March. On 3rd of November, on 9th of November, Ankur sir would be covering quantitative ratio based caselet. On 11th November, Alpa ma'am would be covering the most expected RC questions. And on November 13th, again, Abhimanyu sir would be covering current affairs from April till June. Right, so all these sessions like this one are extremely important, relevant, and you saw the relevance. कुछ पढ़ेंगे, कुछ प्रैक्टिस करेंगे, कुल मिला के दोनों इकट्ठे अपने एफर्ट से क्लैट को क्वालिफाई करेंगे और ये इस लास्ट लैब का एजेंडा है. I sincerely hope that you got something from the session and do not forget to join us for a detailed analysis that is going to get conducted on December 18, right on the day of the exam. ठीक है, all the best guys. ये सेशन हर दिन 9 बजे होगा रात में. डू नॉट मिस इट. आप इसे बहुत कुछ सीख सकते हैं, रिविजन कर सकते हैं, स्क्रैच से प्रिपेयर कर रहे हैं तो वो भी आपके काम ही आएगा. ओके, so thank you guys, thank you for being with me, thank you for being so patient, sticking by me till the end for 2 hours and a half, actually 2 hours and 13 minutes. You guys rock. Your sincerity and dedication will make you qualify the exam along with our joint effort. So this is the session plan. So the next session is going to happen tomorrow, and then we have another session a little after, right? So yes, and this is the AILET revision plan on 6th November, 8th, 10th, 13th, 15th, 17th, and 20th. You can all see it from this section. Please help me. This preparation will help you a lot, रेशमा. आप ऐसा कर सकते हैं कि मैं इस सेशन में लीगल में आपको जो जो पढ़ाया जा रहा है या बाकी सेक्शंस में जो पढ़ाया जा रहा है उसको कर लीजिए बहुत अच्छे से. ठीक है, बस उसको ही कर लीजिए और एक्स्ट्रा कुछ मत पढ़िए, हो जाएगा. ठीक है, चलिए. So that's it for today, guys. Thank you so much. Thank you for being here. Thank you for being so dedicated. If you liked the session, give me a thumbs up. I would love to see your comments and I would love to see that you share the session and subscribe to our channel if you haven't already. You can also follow us on at BYJU'S Exam Prep Law on Instagram. You can like us on Telegram. You can like us on Facebook, join our Telegram channel and also download our app. So guys, thank you. I shall see you again tomorrow. तब तक के लिए सब अपना ख्याल रखेंगे.